Morning, everybody. It is 8:31 on January 14th, 2022, and this is the second day of hearings in case. Oh, I should have had that in front of me. Hold on, sorry. I lost the case number.
It's 21902.
Yeah,
I had 21324.
Thank you. This is the second day in the continuance case number 21324, de novo case number 21902, which is the application of Mr. Tom Ragsdale to revoke orders R2094 and R2094A, or in the alternative, declare unreasonable certain costs imposed by Mewburn Oil Company. We started the hearing yesterday and we'll continue it today. I am Adrienne Sandoval, Chair of the Oil Conservation Commission and Director of the Oil Conservation Division. Will the other commissioners please introduce themselves for the record?
Sure. Good morning, Greg Bloom. I am the designee of the Commissioner of Public Lands.
I am Dr. William Ampuma, designee of the Secretary of Energy.
Thank you. Also with us today is Counsel Chris Moander, and then Clerk for the Commission, Florine Davidson. I think where we left off yesterday was we finished sort of the initial testimony and witnesses from both of the parties, but it sounds like the commissioners may have additional questions for some of those witnesses. Mr. Moander, is there a certain, what's the procedure to either recall witnesses?
So under the circumstances, since the witnesses have been sworn in and are still under oath, you can just recall them, and you can say, for example, the commission recalls, Joe Smith for continued examination by the commission. My suggestion is that the parties be allowed respectively to conduct any additional examination after the commission is done. So that way, any issues are fully flushed out and the commission is as informed as it can be.
Okay. Following that, I think we can have a discussion with the parties about the path forward, closing arguments, deliberations, etc.
That would be fair, because I think right now at this point, the goal needs to be first to get the evidentiary record completed and closed, and then there can be a transition to discussing procedure and so on for the remainder of the matter.
Okay. Commissioners, I think we spoke briefly yesterday regarding, there were, I think, some additional questions from Mr. Hughes, as well as Mr. Ragsdale. Are those still the two primary witnesses who there are remaining questions for?
Yeah, Madam Chair. So from my side, it will be more like for Mr. Bruce to decide who he wants them to respond to the questions that I do have. So it's not strictly to Mr. Q.
Okay.
I might have a couple questions, Madam Chair, for Mr. Ragsdale.
Okay. Mr. Moander, I'm assuming we go in the same order, start with the applicant. You're muted.
Yes, Madam Chair, that would make sense. It would be procedurally consistent. So I think that would be the way to go.
All right. Well, then the commission recalls Mr. Ragsdale. I will remind you, Mr. Ragsdale, that you are still under oath. You were sworn in yesterday. And so that still prevails. So I think we'll start with, well, actually, I'll just ask, Ms. Shaheen, do you have any questions for the witness before the commission does?
I do not, but I would appreciate an opportunity for more or less redirect or rebuttal after the commissioners are done. Thank you.
Yep, absolutely. I'll give you and Mr. Bruce when we speak to the Mewburn representatives afterwards, redirect opportunity.
Great, thank you.
All right, commissioners, let's make sure, Mr. Ragsdale, can we hear you? I can't hear.
I think I see someone there assisting him.
Okay.
Maybe I'll give him a call and see what's going on.
Okay. We'll give it a couple minutes while you.
Madam Chair, they're having some technical difficulties, so I've asked them to call in.
They could use the video capacity and then just call in on the phone.
That's my thought. So hopefully they'll be calling in here shortly.
Okay, I'll watch.
Thank you.
Could you hear us? Could you hear us?
I can. Thank you, Teresa.
Sorry.
Sorry, Tom. Thank you. What? By talking in the phone. Huh? Yeah, please go. Phone?
All right, you want to try again and make sure we can hear you, Mr. Ragsdale?
Yes, can you hear me?
I can.
Okay, all right, good.
Ms. McFarland, can you hear him?
I can. It's a little low, but I think it's going to be fine. He's got a speaker right in front of him there. I'll let you know if I can't. Thank you.
All right, great. Well, with that, commissioners, do you have questions for Mr. Ragsdale?
Madam Chair, I do. Do you allow me?
Yep, please go ahead. Thank you.
Mr. Ragsdale, good morning. And Mr. Ragsdale, I cannot hear you. I'm sorry.
Good morning.
All right, there we go. Mr. Ragsdale, as I was going over my notes from yesterday, I had some questions, and I don't know that you'll necessarily have answers for these, and they may just be things that Ms. Shaheen would want to address in her closing statements, and that Mr. Bruce would want to address as well. But I'm wondering what, if the OCC is sympathetic to your case, what that would look like for you. I know you're looking to have the $3 million in junked well cost, and then I would imagine that you'd want to be reinstated into the pooling order so that you could benefit from these wells if they end up being profitable. I'm wondering first of all, if that's certain, and then what would, if that's allowable, and if there's any precedent for these things that you're aware of.
The last question, well, let me answer your first question. Yes, we're interested in participating in the wells, and we're interested in participating in the cost of the sole well on an individual basis, not the ones that were not the ones that were failed, and when Mewburn did not have an order, the $3 million as you mentioned. We're interested in paying the $9.3 million. We offered to do that in the past. We did pay them, and they deposited our check, and then they said we owed the additional monies, our proportionate share, which was about $160,000. That's what's really at stake here, is that $160,000. That would be my proportionate share of the $3.1 million. But yes, and then they would put us back in the well, retroactive day one. We'd pay them actual cost, probably is what would happen now. It becomes an accounting matter. And yes, but yeah, that's a very good question. And yes, sir, we would want to be placed back in the well, and we would pay our cost. And it's under whatever order that you all, the commission, would stipulate to us if y'all had such verbiage in a decision here. But they would have to go back and make it retroactive on day one and place us back, and then whether we pay we'd pay our full well costs, and then they would have to go ahead and pay us all of our revenues to date that they have suspended or withheld or placed in their other numerous limited partnerships that they have. And you did ask me a last question. No, there was a last question. I wanted to answer that too. If you could just rephrase that last part of your question.
Of course. Thank you, Mr. Ragsdale. I think that question is there any, what rules and regs would you point us to that could allow for this to happen? I don't know that it's something that, I guess I believe it's something that the OCC can do, but how we get there is of interest to me, and basing it in rules and regs would be most helpful. I haven't had time to do that research, so I'll give you this opportunity to point us in that direction, and I'm sure the attorneys will address this in their closing statements as well.
Now I remember the question you asked me, if we knew of precedent or so. And that's a very good question, an excellent question. I do not. I wish I had an answer for you. I wish I knew about some precedent, and I do not. But I wish I could answer your question. It's probably best if I defer that to Ms. Shaheen and see what, maybe in the written statement, she can go ahead and produce some case law or some precedent, as you mentioned.
Thank you, Mr. Ragsdale. No further questions at this time, Madam Chair.
Thanks, Commissioner Bloom. Commissioner or Dr. Ampoma, do you have questions for Mr. Ragsdale?
Yes, Madam Chair, I do. Sorry. Yeah, so Mr. Rustil, good morning. Once again. My question to you is that was there, we've gone through all the testimonies, but I just want to be clear for myself here that was there at any point in the notices, for the new well that is in contention, did Melbourne state that that particular well is a substitute well? Was there at any point did they specify in the notice or the application that the well that they added to the AFE, the actual well that we are talking about now, was a substitute well?
Good morning to you, Dr. Apanoa. I don't know the answer to that. I don't want to give you a wrong answer. I do not know of any mention to the division or the commission of a substitute well that was mentioned. I don't know of that. But I don't want to give you a wrong answer and say I know for sure that there was not and that there was. I don't believe that there was. And,
So then I'll take that answer as you don't know, but I really want an answer to that. Now, so let me also put it this way, that if at any point in time you saw, or let's say was reported to the commission, to the division, that this particular well is a substitute well for the two already filled attempts, would there be this hearing?
I'm sorry, you said at this hearing?
No, I'm saying that I'm asking you that if Melbourne have included in their notices and also their application to the division that the 1510 well is a substitute for the 1015 wells, would we have been here, for this hearing?
Yes. Okay. Let me say my understanding is whether they said a substitute well or not, the mistake was made back in July of 2019 when they drilled those two wells. They did not have an order. So whether they say substitute or not, which I believe they did not even mention a substitute well, but the mistake was made. They made their mistake back in 2019 in July when they drilled the wells out of division. I don't think they can lump those costs on those on a future well. I don't know if I'm answering your question though.
Yeah, it's not clear. It's not clear.
Okay. Well, no, I do want to answer it. So yeah, ask me again then. I can understand the question.
Now I'm just asking you because if they included in the application that this particular well 1510 is a substitute well to the previous field drilled wells,
Right.
Do you believe we'll be having this hearing?
Yes, I do believe we'd be having this hearing. Yes, absolutely. Because I don't believe it's not. I don't believe the division would allow them to place those costs in the very simple matter that they did not have an order.
Yeah, but according to the rules, if it is a substitute well, then they do have, the opportunity to recover the cost from the field ones, according to the rules that we've all gone through yesterday.
Okay. Then I I stated earlier, I do not believe they ever mentioned substitute well, and I believe Ms. Shaheen talked about the definition of a substitute well yesterday, and it was actually the division's or the commission's definition of a substitute well.
So let me ask you your interest in the junk wells. Do you have any interest in the junk wells?
Yes, sir.
Then why you don't want to pay for it?
Okay, I'm sorry. I had it. Okay. The very simple rule is they have if we did not sign a JOA, the rule is, and we did not sign a JOA, then we have to be force pooled, and they did not have a pooling order, and they drilled the wells, and the pooling order would stipulate about the costs. That's the rules that we have to follow. and they did not follow the rules here. They drilled those wells at their own risk, and they knew, Dr. Ovala, that they did not have an order. They've given multiple excuses and reasons for doing so, but, you know, they broke a rule. And you know, that's why I don't think that we should be obligated for the cost. We did not know they were drilling the wells. They didn't share the drilling reports. They didn't mention anything to us. We didn't have the opportunity to participate with the pooling order. And that's what this is all about.
So let me give you the chance to respond to what Mr. Robb said yesterday as part of his testimony. He talked about, you know, they went ahead with the pooling order still pending. They went ahead to proceed, knowing that they can take about 5% risk, you know, knowing that they've already been able to pool about, or say, had an agreement with about 95% with all the interest owners in there. So they were able to take the risk of that remaining 5%. Can you chime in on that statement for the commission to understand what type of risk he's talking about?
That's a very good question. I'm glad you brought that up. Mr. Robb did bring that up yesterday. He said we proceeded and we took the risk, or we assumed the risk, and we knew the risk of drilling without a force pooled order. And I think he had mentioned there's about 10% of the people, of which Mr. Ragsdale owned about, 5% of the 10%. So when he's saying the risk is they had to assume the risk of any, the risk of a failure, which doesn't happen that often, but it happened here. And that's the very statement that he made yesterday, that they knew they were taking that risk. And as I'd mentioned, those costs, they should absorb those costs. That risk was on them. We were not signed up. We were not given the chance, the opportunity to participate. We did not want to sign the JOA, so we have to wait to be force pooled. And they jumped the gun, and they took that risk, as Mr. Robb stated yesterday. So that should mean the risk is that they would pick up any costs of problems or failures. It's all about risk and money, as you say, drilling these wells, right? And so he did say we knew the risk and we took that risk. You're right. And it's about cost and money, because we were not signed up to take that risk. We had not been given the chance to participate, to take that risk and share in the risk. It is as though they assumed that risk themselves, that 10% that wasn't signed up, if there were going to be any problems, that risk was theirs.
Thank you, Mr. Ragsdale. Madam Chair, no further questions from my side for Mr. Ragsdale.
Thank you, Dr. Impoma. I just have, I think, a couple questions. From your perspective, Mr. Ragsdale, are none of the additional approximately $3 million appropriate?
Yes, ma'am, that's correct. None of that 3.1 million, whatever cost of the 3.1 million associated with whatever cost that Mebane had before getting the order should be at their own risk, as Mitch Robb stated yesterday. Yes, ma'am.
So I just want to make sure I fully understand. So you're not saying that it should have been $1.5 million instead of 3.1. You're saying the entire 3.1 was inappropriate and you're seeking relief from the entire 3.1 million?
Yes, ma'am, that's correct. To us, it didn't matter if they spent $10,000 or $10 million. Whatever they spent at their own decision, at their own risk, before they had an order, should have been their own risk, their own liability. Yes, ma'am. Everything they spent prior to the order. Yes, ma'am.
Okay. Sorry, I'm just trying to make sure I don't have any other questions. I think That's it for me. Miss Shaheen, do you have any redirect for your witness?
I don't have any redirect based on, well, actually, I do. Let me start with some of Dr. Ampoma's questions. Mr. Ragsdale, Dr. Ampoma asked you about the fact that Mewburn claims to have had the right to drill. Do you recall that questioning?
Yes, I do.
And it's my understanding that the question here is not whether Mewburn had the right to drill, right?
That's correct. That's not the question here. That's not what is at stake here. That's correct.
The question is, can they impose the costs of the failed attempts when they didn't have a pooling order, right?
Absolutely. Yes, ma'am. That's correct.
He also asked you about whether the commission, if Mewburn had informed the commission or division that this was a substitute well, would we be at this hearing today? Do you recall that question?
Yes, I do.
And I believe I want to turn to the list of undisputed facts here. I should have done a little preliminary work so that I can find it. The disputed facts, I'm going to share my screen here. They don't directly address the question that
I need
Dr.
to give
Ampoma asked.
You, oh, I think I need to give you permissions. Hold on.
Okay.
All right, you should be good now.
Okay, thank you. All right, so here I'm, this is the revised list of undisputed material facts, and here at paragraph 1 begins the discussion about the application in case number 20809, in which Mewburn sought to pool the same acreage that it previously sought to pool in case number 20580. And these series of paragraphs address that question. So Mr. Ragsdale, if you could just take a look at this, and I'll ask you a few questions about them. Sorry, I'm going a little fast. Tell me to stop if you need me to. So I think paragraphs 21 through 29 address the application in case number 20809. And Mr. Ragsdale, just let me know when you're ready to entertain a few questions about this.
I'm ready, I think.
Okay, so in paragraph 21, the parties have agreed that the application in 20809 sought to pool the Bone Spring Formation, the same acreage as case number 20580, for the purpose of drilling the 1510 wells. Do you see that?
Yes, I do.
And then paragraph 22 kind of repeats the same information, stating that the application informed the parties that Mewburn was seeking to pool the Bone Spring Formation for the purpose of drilling the 1510 wells. Do you see that in paragraph 22?
Yes, I do.
And so you received notice of that case and that application, but you didn't enter an appearance, correct?
Yes, that's correct.
And you didn't enter an appearance because there was no mention in that application about a substitute well. Is that correct?
Yes, that's correct.
And in fact, we're going to paragraph 23 again of the parties' undisputed facts. Mewburn's application did not even reference the 1015 wells, did it?
No, it did not.
And in fact, going to paragraph 24, the application didn't request that all 4 wells be pooled together, did it?
Madam Chair, I object. This is in black and white in writing. Why waste the time? What has already been stipulated to?
Well, if I may, Mr. Bruce, it appears that this is a lot of information we've thrown at the commission, and appears that maybe they haven't been able to review the revised statement, which I admit we submitted on Wednesday. So they haven't had the time to fully appreciate what undisputed facts have been submitted for the record. And in light of Dr. Ampoma's questions, I think it's perfectly proper for me to highlight those undisputed facts for the commission.
Ms. Shaheen, I think it's fine to go over some of this briefly, but since it is in writing, let's make it somewhat brief. But if you want to highlight a handful of them, go ahead.
I'm almost done. The paragraph 29 is the last one. So it wasn't until the pre-hearing statement was filed in case number 20809 that Mewburn asked that the commission, the division, pool all 4 wells together, the 1015 wells and the 1510 wells, and that's paragraph 25. Do you see that, Mr. Ragsdale?
Yes, I do.
And then in paragraph 26, it goes on to explain that the notice letters didn't inform the interested parties about Mewburn's intent to include all 4 wells, correct?
Correct.
And at no time, we're looking now at paragraph 27, did Mewburn inform Mr. Ragsdale that Mewburn intended to incorporate the 1015 wells in the same case with the 1510 wells, correct?
Yes, that's correct.
And then finally, in paragraph 29, Mewburn's counsel, this is Mr. Bruce. This is what this, and I won't read this into the record. I'll just highlight it here for the commission. Paragraph 29 is what Mr. Bruce told the division at the hearing in case number 20809. And I will note that it does not refer to a substitute well. It simply says they want all 4 wells in the same application. Do you see that, Mr. Ragsdale?
I do, yes.
Thank you. So that concludes my line of questioning there. I'll stop sharing now.
Thanks.
May
I
I
actually,
I do have a few more questions. I'm
go
sorry.
ahead.
Dr. Ampoma also asked you about whether you had an interest in the junk wells. Do you recall that question?
Yes, I do.
And I believe you explained to him that that at the time that those well, you had an interest in the minerals that were being that were intended to be produced in those junk wells, correct?
That's correct. I had an interest in the minerals out there. Yes, that's correct.
And you had received a well proposal to pool a 1,280 acre unit, which included those two, the 1015 2H well, correct?
Yes,
And you chose not to sign that JOA, correct?
that's correct. Yes.
Instead, you preferred to be force pooled on that specific spacing unit, correct?
Yes, that was the only other option versus not signing the JOA.
But there was never an order entered prior to them drilling. I think that's clear, right?
There was not an order. That is correct.
And so you never had an opportunity to participate in the drilling of the 1015-2H, correct?
Yes, that's correct.
There was quite a bit of testimony yesterday about March of 2020 and the letter, the election letter, and the timing of the election letter and the timing of your response to the election letter. This was March of 2020, is that correct?
Yes. Yes, ma'am, it was.
And there were some unique circumstances going on in March of 2020, is that right?
There were a number of multiple unique circumstances. Yes, ma'am.
And one of those is that was the onset of COVID. Do you recall that?
Absolutely, I do. Yes.
And there was a lockdown at that time, even in Texas, right?
Yes, there was.
And were there some personal circumstances that concerned Ms. Stanford at that time?
Yes, there were.
Can you tell the commission about what was going on with Ms. Stanford?
Yes, this has not been brought up yet, but Ms. Stanford's parents that she was very close to lived out in California, and they were both elderly, and her father had fallen sick at the time, a few months prior, and eventually he went off into hospice. And Ms. Stanford was trying to get out there as soon as possible to spend time with him. So, you know, she wasn't always at the office. And her father did pass away, I believe it was March 31st. So she was out for a few weeks, you know, with family matters, 2 or 3 weeks. And so she wasn't around our office very often in that period of time.
So in addition to your questions that you had that were unanswered by Mewburn with respect to those junked wells being imposed on the 1510-2H, in addition to those questions that you had that had not been resolved, you also had, there were, if you will, an act of God with respect to COVID and Ms. Stanford's personal difficulties that were at play during
I
March of
object to
2020.
the editorial content of this little discussion.
Okay, if you heard my
It
question,
wasn't
Mr.
an act of
Ragsdale.
God, it was an act of the Chinese, if you want to know.
Well, that's debatable.
Editorial comments on both ends, to a minimum, please.
Okay. Can Mr. Ragsdale answer the question?
And I'm sorry, I forgot what it was. I'm sorry.
Okay, just to clean up the record, I was just asking you to summarize the fact that there were extraordinary circumstances at the time during March of 2020 when this election letter went out, and there were questions about the cost, correct?
Yes, there were extraordinary circumstances and events going on with the COVID and then with the personal, the death in the family of Ms. Stanford's father. Yes, there were.
Those are all the questions I have for Mr. Ragsdale. Thank you for the opportunity.
Mr. Melander, I actually remembered another question I have. Is it too late to circle back?
The whole point of this hearing, Madam Chair, is to get to the bottom of things. So if you've got some additional questions or a question you should ask, and then I would see if the parties have anything else they want to ask, and then you could probably wrap it up at that point.
Okay. All right, Mr. Ragsdale. So yesterday, I believe there was testimony when I asked, I think it was Mr. Robb, that Mewburn had just stopped with the 2 failed wells and not then done the substitute wells, the costs would have still gotten passed on to the parties. So there would have still been a situation where you might have had to pay a share of the $3.1 million. Is that your understanding as well?
No, that's not my understanding at all. it was just the simple fact that there's rules and laws with the division and commission, rules should I say, and the rule was, you drill at your own risk when you drill without an order. And we had not been given the chance to participate in those wells. And I don't think they should be allowed to place any of those costs because it's just a very simple rule. It's black and white to us. And it's y'all's rules that they broke, that they violated. So I don't see any of the costs being.
Go ahead.
I don't see that they can pass along any of the costs until they have an order, and it's agreed upon order submitted by the division or commission.
So really the crux of your issue comes down to if there isn't an order, then they can't pass along costs of the failed wells. If there had been an order, they could have passed on cost of the failed wells. Is that correct?
Yes. The real meaning to us is that if you do not have an order, you're drilling at your own risk and own peril. So you take those risks and thus the costs associated with it.
Okay.
And when we do have the orders, we're always forced, if we want to participate, to prepay, in which we do. We prepay.
Okay. Thank you. That was my last question. Ms. Shaheen, I will give you one last opportunity to redirect if you have any questions specifically about what I asked.
I have no further questions. Thank you.
Thank you. All right. Thank you, Mr. Ragsdale.
Madam Chair, may I ask some questions?
Mr. Moander, I mean, I think.
Well, so my question is, I just realized this may not have happened. I don't believe council had the opportunity did he ask some follow-up questions after Ms. Shaheen? So then he should be given the opportunity to ask some questions since we're doing a whole round of this.
Okay. Go ahead, Mr. Bruce.
Regarding Ms. Stanford, she testified about that at the last hearing, and that was a tough situation for her. But you previously testified that you and your assistant, not someone other than Ms. Stanford, were in the office for most of March. Did you not?
I did testify that. I did.
Okay. Couldn't you have made your own decision? You own the company. I mean, you own the interest. Couldn't you have made the decision to elect and send a timely notice of election in?
You're asking this question, and Ms. Stanford works for us in that land capacity. That's her job. I don't think Curtis Mewburn knows about these orders. I don't think Curtis Mewburn knows about AFEs. Jim Bruce, if you're asking me to know about...
I would object to the speculation. Just answer the question.
Okay.
You were in the office.
No,
you could. You own the interest. Made an election.
The answer is.
Okay, guys, can't talk over each other.
I'm sorry. I
let's,
do too.
Yeah, let's.
Go ahead,
The answer is no. Ms. Stanford had that information. Ms. Stanford is our representative who worked with Mewburn. In particular, I believe it was Mr. Robb, who Ms. Stanford was working with. And I always relied on Ms. Stanford to tell me what the situations were. She works for us, and that is her job description. So I did not have those documents. I was not aware of all of them. She talked to me here and there, but she talked to me when she could, and I don't remember any election dates, and I know she was questioning those costs and trying to get answers. That's what I recall. And so if she had told me we had a deadline, then she'd get me the documents, and we'd sign them and send them in. And I believe she was waiting on those answers to these inflated costs or these junk well costs being inserted on our AFEs after the fact that were in violation of the division's rules.
It's not in violation of division's rules. I'll state that flat out.
Mr. Bruce,
I'm
just
sorry,
ask
Madam
questions,
Chair.
please.
I just have a couple more questions.
Okay.
If you had received an election notice for the 1015 2H well, prior to commencement of drilling, would you have elected to join in that well?
The election letter being a forced pooling order?
Yeah, the forced pooling order plus, like, Mr. Robb sent in a notice to you in, March of 2020, an election letter and an AFE and the pooling order. Would you have signed the AFE denoting your interest in joining voluntarily in the well?
Yes, we would have.
And again, assuming there had been well costs due to problems in drilling, you would have been subject to those increased well costs.
With a forced pooling order, yes, we would have been subject to those, yes.
Just looking for one final thing here. Have you've read the order that you're objecting to, have you not?
I've read bits and pieces of it when certain sections were pointed out to me.
Yesterday, Madam Chair was asking some questions about a provision where the pooling order provides an opportunity for any interest owner who objects to well costs to object to the division. Just assume that is a given for now. I forget the paragraph number. I don't have the order right in front of me.
And I'd just like to clarify for the record which order Mr. Bruce is referring to.
The -A, the second.
-A. Okay, thank you.
Okay. You could have paid your 4.89% of whatever the well cost was, a little over 12 million, I believe. And then you could have paid your share of that, and you still had the right to go to the division to object to well costs under the pooling order, would you not?
I think that's oh, was somebody interjecting?
Well, I was just going to object on the basis that this is something that's in writing that it's being asked a question about, and if Mr. Bruce wants to ask a question about particular language in the order, we should be looking at the particular language in the order.
Mr. Bruce, you want to reframe that or answer it regarding or in relation to the order?
Well, let me, I printed up the order, now I can't find it. Give me a second.
I believe it's attachment D to Mewburn's exhibits.
Attachment,
D as in dog.
oh, okay. Thank you, Ms. Shaheen. It would be on page 3 of the order, paragraph 28.
And if you like, I can share my screen so everyone can see
Oh, go
it.
ahead.
Let me just find the page here. Is this the correct? Oh, wait. Sorry, gotta share. Is that the language we're looking for, Mr. Bruce?
Paragraph 28. I can't see it, but I presume
All
you're.
we see is
Oh,
your desktop.
oh, really? You don't see the document? I must have,
No.
well, somehow this got moved around. Let's try that again. Okay, so I'm going to back up to paragraph 28.
Yes, please.
Yeah. Mr. Bruce, I believe everyone can see it now.
Okay. I'm not going to read it, but you can see that says when in the middle of the paragraph, a pooled working interest owner can file a written objection, and then the division will determine reasonableness. So could you not have paid under protest the share of $12 million and then sought, just like you're doing now, to object to the well costs?
You know, there's a lot of things we could have done, and that's one of the things we could have done. We did something similar. You know, we paid the well costs of the original AFE that was submitted to the division. We paid our 4.89%, our 5% basically, of the $9.3 million, the one that was the proper AFE. And we did submit that to MIRB, and we paid them.
And just one final question, two questions, I guess. You are subject to that JOA because of that working interest you bought from your old friend, right?
Well, now you're talking about two different sets of interests that, you know, that I own in the property. There's the small one.
And I'm not, but you are subject to that JOA that covers this well and other acreage.
Yes, I am, from that interest that I derived from Tracy Anderson, which is
okay. That's all I'm asking. That's all I'm asking. But as a result, you have for what, a couple of years now almost, you've been receiving joint interest billings on the 1510 2H well.
I believe so. That assignment was the middle of, 2020, so maybe for the past year and a half, maybe.
Okay. But by receiving those joint interest billings, those are for actual well costs, right? So you know what the actual well costs have been for quite some time.
Objection, foundation.
And
Hold on a
yes or
second.
no, and that's my final question.
Ms. Shaheen, do you object to the yes or no question, or?
Well, I thought that Mr. Bruce referred to the 2H, and I don't believe he's receiving.
Well, I'm sorry, I'm confused. Is it the 1H? Whatever.
No, it is the 2H, and I might be getting myself confused. I apologize.
Anyway, I'm talking about the $12 million well, whatever well that is.
Right, that's the 1510 2H.
Okay.
My apologies for interrupting.
So the question is simply, you've received JIBs with actual well costs for a year and a half now, so don't you know what the actual well costs are?
Yes, but I'd like to clarify for the commissioners, when you say well cost, I mean, you're mixing this up a lot. The JIBs that I receive are what we call LOE, or lease operating costs. They're production costs. They have nothing to do with the drilling or completion. The well costs that I received from Ms. Anderson, or that my interest in the well was after it was drilled. And so the well cost that I receive, when you say that general term well cost, it'd probably be better if you specify for the commissioners and myself, are you talking about drilling and completion cost? Or are you talking about, producing well cost, what it costs to produce the well on a monthly basis? There's a difference. There's a big difference.
Thank you, Mr. Ragsdale.
Was that your final question, Mr. Bruce?
Yes, Madam Chair.
Okay. Yes, Mr. Melander, technically, did we allow Ms. Shaheen to redirect?
I would ask if there's anything additional from anybody at this point, and let's wrap up Mr. Ragsdale's examination.
Commissioners, do you have anything additional?
I only have one question about paragraph 28.
Madam Chair, I have no further questions of Mr. Ragsdale.
No further questions from me. Thank you.
All right, go ahead and wrap it up, Ms. Shaheen.
Mr. Ragsdale, taking a look at paragraph 28, and it says that no later than 180 days after the operator submits a Form C-105, which is a completion report for the well, the operator shall submit to OCD and each owner of a pooled working interest an itemized schedule of the actual well cost. Do you have any recollection of ever receiving an itemized schedule of the actual well cost from Mewburn?
No, we do not.
Thank you. That's all I have.
All right, thank you. All right, Mr. Ragsdale, thank you for your time this morning.
Thank you.
All right. With that, I think let's move to Mr. Cude.
Okay.
Mr. Cude,
Travis, are you there?
There.
Yes.
Okay, great. I just want to remind you that you are still under oath as you were sworn in yesterday. Commissioners, do you have questions for Mr. Cude?
Madam Chair, I do not.
Dr. Impoma, do you?
So I'm not sure whether this question will be appropriate for Cute or for Rob, but I can go ahead and ask, and just in case Rob needs to respond to them, I guess he can. When
Okay. Yeah, ask Mr. Cude, and then Mr. Cude, if that's not an appropriate question for you, it's more appropriate for Mr. Rob. Please let the commission know.
Yes, Madam Chair.
Okay, thank you. So, Mr. Q, do you know, so the same question that I asked Rushdell, do you know at what point, or did you know why Melbourne did not add the substitute, that substitute in the new well, for the old wells that was unsuccessfully drilled in the notice when they served the OCD and then also the parties involved? Do you know why?
Dr. Impoma, to my knowledge, Mewburn complied with the notice statutes, and what is required to be included in the notice. For the most part, it really just identifies the common source of supply and the proration unit that's being pooled. I mean, that's the regulation, and I think in all three pooling orders we have, the notice requirement has been satisfied. As to what's required in the notice, I think as we pointed out earlier that, some of that commentary is included in the pre-hearing statement and in the actual hearing itself. But as to the particular notice, Mewburn complied with the notice requirements.
Yeah, because I know for notices, and we are all in the industry. Because if, let's say, Melbourne has included that this particular well that we're going to drill is going to be a substitute for these particular wells that were junk wells. To be honest, I guess Melbourne would have been in a better position, in this particular situation. So I guess, so your answer is that not adding the substitute in your notices doesn't necessarily mean anything, right?
Yes, Dr. Apono. To my knowledge, Mr. Bruce sends out the notices on Mewburn's behalf, and so he, includes within that notice letter, what is required per the statutes. So,
Thank you. So, do you know the timeline when Melbourne decided to add the junk cost to the new AFE? Do you know?
I would believe that it would be, after the time that we received the amended order for our hearing. So I guess the -A, where all 4 wells were included in that order, and that we deemed that we had drilled a substitute well, that at that point, because the regulations state that historical costs that are reasonable for the junking and abandonment of wells, because that's a reasonable cost that can be imposed, we added that cost to the AFE that was sent out to the parties at that point. So it would have been after we received the pooling order.
So that is after you received the pooling order.
Yes, sir.
And so does that mean that the OCD is aware of the situation of imposing this additional cost on the new well?
I believe that Mr. Bruce testified and is in our exhibits that was brought up at the pooling hearing, for the 1510 2H wells, that we seek to recover, to have an order encompassing all of those wells. So to recover those costs as well in that order.
And that order has been approved?
Yes, sir, it has.
Okay. Thank you. No further questions, Madam Chair.
Thank you. Commissioner Bloom, did you say you didn't have questions, or did I make that up?
You heard me correctly, Madam Chair. I had no further
Okay.
questions. Still
All
have one.
right, thank you. I just have maybe a couple questions, Mr. Cute. So the $3.1 million additional costs, do you have any comparison or from either other wells within Mewburn or other companies that demonstrate that additional $3.1 million to junk those 2 wells was appropriate?
I know that every situation is different, but I don't, from our end, we're not imposing anything that didn't occur in the operations of those wells. We spent over 20 days on location with a drilling rig. We have strings of casing, we have cement. Those were the actual costs that Mewburn incurred. And so I don't know that I have a comparison for you, but, like we said, no other party has objected to the reasonableness of those costs. And I think including Mr. Ragsdale himself, that those were the dollars that we spent in those attempts.
But you don't have any examples or comparisons to show that that would be a reasonable cost? And it shouldn't have maybe been 1.5 million as opposed to 3, or 2 as opposed to 3, or?
I don't know that I have any examples, those were the costs that Mewburn incurred.
Okay. And those were actual costs?
Yes, yes. I mean, at the point that we provided those costs to the, well, not, I mean, obviously our JOA partners would have paid those, via our billing system, but as we sent the notice out under our second amended pooling order, we identified those as the actual costs incurred, not an estimate. I believe is in Mr. Rob's proposal letter with the 1510 2H AFE.
And in those costs, you don't pass on any sort of upscale, like you got your operation, they're like the actual cost. There's no sort of upscaling of the cost.
That's correct. They're the actual costs.
Okay. All right, that's all of the questions that I had. Commissioners, any further questions before we go to Ms. Shaheen?
Madam Chair, one quick one. So I remember yesterday you brought the cost up, and Mr. Bruce was going to add an appendix for us to know the cost. I remember there was a statement on that we're going to give us some examples of the cost. So I don't know if it's still the case.
What was I supposed to do? I can't recall.
I recall that Madam Chair asked about the reasonable cost, and Melbourne was going to provide as an attachment, as I recall, all the cost.
Well, what I said was we would try. I mean, we would try to do something, but we only had a night to do it, not a full night. I don't have that. I said we would continue to try to look for some case law on that issue, which we would provide to the commission, is I believe what I said. And I'm not much of a research wizard, so I've handed that off to someone else, and I haven't heard back yet.
Thank you.
Shaheen, do you have any additional questions for Mr. Jude?
I do have some follow-up with respect to Dr. Ampoma's questions. I have a vague recollection that I started to ask Mr. Koo these questions yesterday, and he deferred them to Mr. Rob, but I'm happy to try with Mr. Kood, and if he can't answer, perhaps I could ask them of Mr. Rob. But they relate directly to Dr. Ampoma's questions about the order and Mr. Kood's response to his questions.
Go ahead.
Mr. Kood, do you recall Dr. Ampoma's questions about the pooling order just now?
Yes.
And you referred to 3 pooling orders, I believe, but do you mean 3 pooling orders or 2 pooling orders? What order are you actually referring to?
I believe I was referring to the 3 orders that we have received. So there are 2 pooling orders, and then there's the order number R21631, the division's case, or the division's order on this case 21324.
Okay, but the pooling order, I think that you were testifying about is the order number R-20894-A, is that right?
Yes.
That's the order in which all 4 wells were pooled together in one order, correct?
Yes.
And is it unusual for Mewburn to receive a forced pooling order in which multiple wells are included?
No.
And what is Mewburn's practice with respect to sending out an election letter and AFEs for each of those wells?
That's probably best asked of Mr. Rob. I believe my response to Dr. Ampoma just referred to that in the orders that I have reviewed, that we have met the notice requirements in those orders. But as to our process for proposing wells, that's Mr. Rob's territory.
What are the notice requirements that are in those orders?
Well, I suppose if we could pull up the order number R-21631.
That's not the order that's at issue here. The order that we're discussing is 20894-A.
And I would object because I don't think that order talks anything about what, about notice, other than the fact that notice was mailed to the parties being pooled.
I think that's right. That's why I'm trying to clear this up, because I don't know of any notice requirements in the forced pooling orders.
Well, I believe what my response was that Mewburn satisfied the notice requirements.
Okay, I think that clears it up for the record then. Is it your understanding that Mewburn will send out a separate AFE for each well in an order?
I'll defer that back to Mr. Rob.
Is it
Yeah,
Mewburn's
he handles-
practice? Excuse me, I'm sorry, I didn't mean to interrupt.
I was just saying that he would be the expert as to our process there.
Do you know of any other time in which Mewburn has used one well that's been approved in a compulsory pooling order to substitute for another well that's been approved in a compulsory pooling order? Has that ever occurred with respect to any other forced pooling order that Mewburn has received?
I believe, as I testified to yesterday, that I am not aware of this situation occurring in the past.
And I believe you, if I misunderstood your testimony, please correct me. But I thought I heard you say that the order approved that Mewburn could recover the cost for the failed wells. Did you make that statement earlier in response to Dr. Ampoma's questions?
I believe my response was that all 4 wells were included on the order.
Okay, so there's no specific provision in the order that allows Mewburn to recover the costs for the junked wells as costs for the 15-2H, right?
Yeah, I believe my response was that's in the regulations.
What's in the regulations?
That Mewburn is able to recover reasonable costs from a junked and abandoned well if a substitute well is drilled.
Why didn't Mewburn ask the division to approve a recovery of its costs for the junked wells?
I did not testify in that hearing. I can't answer that question.
Those are all the questions that I have for Mr. Cood. If there's an opportunity to ask Mr. Rob the questions that Mr. Cood couldn't answer, I'm happy to do that. But that, of course, will be at the commission's discretion. Thank you.
Thank you, Mr. Cood. Actually, Mr. Bruce, do you have redirect?
I can ask him a question or two, maybe, you know, if it's okay with the commission, recall Mr. Rob and Ms. Shaheen could get answers to the questions that Mr. Coote didn't know.
Yes, I think we're planning to call Mr. Rob next.
Okay, then I really only have one question for Mr. Cute, and I think I've asked you this before, but I can't remember. But the junked well costs, you said they are actual costs incurred in the drilling and the plugging and abandonment of those wells. Do you professionally consider them to be reasonable well costs?
Yes.
Thank you. That's all I have, Madam Chair.
All right, thank you. Thanks, Mr. Cute, for your time today and yesterday. Mr. Rob? Good morning, Mr. Rob. Just want to make sure we can hear you.
Good now?
Yep. All right, great. Just want to remind you that you are still under oath and were sworn in yesterday.
Good.
Commissioners, do you have any questions for Mr. Rob?
Chair, I do. I just want to clarify this with Mr. Rob. So I just want to know, just to be clear, because it was a little bit confusing to me just now, the Melbourne did not ask OCD to recover the cost from the junk wells on the new AFE.
On the new AFE, no. We considered all the wells, the two junked wells and the new one, the same.
And so did Melbourne actually secure like an agreement from OCD that the 1510 well is a substitute for the two junk wells? Was there any agreement?
We didn't obtain one, but it's in the rules and regulations that our wells qualify as substitute wells. So after reviewing that, we didn't see where we had to notify of substitute wells, since we had the right to do it under the rules and regulations.
Madam Chair, I want to clarify. So under Melbourne's oil company's exhibit list, they do have the division order. Are we considering that as part of this case? So this one is to Madam Chair.
Which order?
So Melbourne's exhibit or their statements, you know, they do have the witnesses. So the engineer, Lamman, and there's third one, that is a division order. And it was not as an evidence. So I don't know. Are we considering that?
So this is a de novo case, which means basically we do not consider what was decided from the division level. It's a new case.
So can they take that out? Because it's still in the document.
I guess I'm not, like, take out the order?
So in here, you know, in the document, that has all the evidence that we are reviewing for the case. It is there as part of the exhibits. So if we are not considering that, is it fair for the parties to cross that so that the commission doesn't need to refer to that at all for records?
Madam Chair, if I may, it's Mewburn Exhibit 3.
Okay.
Yeah, it is. So that is why I want to be clear on that, that if it is acceptable to be an exhibit in this case.
Let me pull up that one real quick. I have so many documents up right now. Okay, so this is the previous order for the case at the division. I mean, I think, Mr. Melander, that this should not be part of the consideration for this because this is a de novo case, correct?
So which document is it? Because I've got a lot up too, and
It's
Mewburn Exhibit 3, sir.
yeah, it starts on of the case 21902 de novo Mewburn exhibits. It starts on page 36.
let me.
Basically
I think
it's order 21631. It was the decision on this matter from the division.
So the whole point of this hearing is to have the parties put on the case independent of the lower level. I would advise the commission that, well, those findings, I understand why there is a desire to discuss them. I would suggest that it's inappropriate because the merits that are presented in this hearing alone should form the basis for the commission's ultimate decision. And the lower level, and I apologize because I tend to call this lower court out of habit, but the lower level decision from the division should not be part of the record or the evidence considered by the commission.
My only comment is I'm not sure what Mr. Robb was going to refer to in this order, but if it was simply the regulation itself, I see no objection. I see why he couldn't just point to the regulation because that's not a finding, that's in the rules.
And Madam Chair, I would agree with that assessment that
Yeah.
if Mr. Robb's going to testify about the reg, then that would be appropriate.
I don't even remember where we were question-wise.
Where do I?
Yeah, so I was asking the question and I wanted to have some clarification on that evidence, whether it is admissible as part of the case. So I guess I do not have any further questions for Mr. Robb.
Commissioner Bloom, do you have questions?
If you're all, excuse me.
Sorry, what did you say, Commissioner Bloom?
No further questions. There was one thing kind of left hanging though, and that was yesterday. We alluded to this and I got cut off, but kind of back to what Dr. Mpoma had mentioned. There was talk yesterday about a supplemental affidavit being filed regarding the well costs of the junked wells. And I would just like to put that to rest. I mean, I don't think we want that coming in after we close today because there'd be no ability to discuss it and have the sides weigh in on it. So if we could agree, I think that ship has sailed and will not be receiving another affidavit about those well costs.
I mean, generally, I agree because if it wasn't presented in the case, it wasn't presented in the case.
Yes, and the side wouldn't have the ability to examine it and discuss it. And we wouldn't have the ability to ask questions about it. So I think we could let that go.
Is it the commission's position that that evidence might have been foreseeably needed, but it wasn't put in the record?
Yes,
Okay.
but we don't make parties cases.
I have no further questions of Mr. Rob. Chair, thank you.
Thanks. I guess my one question, and I sort of asked this yesterday, and then I asked Mr. Ragsdale this morning, and I just want to make sure I recall Mewburn's response correctly. If Mewburn had decided to just stop at the point of the 2 junk wells and not proceed to doing the substitute or mirror wells or whatever we're calling them at this point, those costs, the additional $3.1 million, and those costs would still have gotten passed off to the parties because of the risk that was assumed by them as well as Mewburn. Is that correct?
Yes. So in, I guess, this case, they would have been proposed under the original order very soon after we junked the well. So no one would have known if the well was junked or not. We would probably still be drilling. So then they would have a chance to elect, and Mr. Ragsdale testified that he would have participated before knowing about the junked wells, and he said that he didn't know about the junked wells at this time. So yes, they would have been passed on in proposals.
Okay. So there could have been a world where parties just, if Mewburn had just stopped at that point and not proceeded with the additional wells, there could have been a world where parties were just having to pay out and not getting anything in return down the road.
Yes, but I believe we acted as a prudent operator in continuing to drill.
Okay.
But yeah, if we just stopped, then yeah, the cost would have been where they were.
And parties would have still had to pay those costs. They just wouldn't be making any profits on the back end.
Correct.
Okay. That's all I have. Ms. Shaheen, do you have any questions for Mr. Rob?
I do, and let's start with his testimony just now. Mr. Rob, are you saying that Mewburn, after having attempted to drill those 2 junked wells without an order, that Mewburn would have used a subsequent order and not informed the force-pooled parties of the junked wells, and thereby attempted to impose the cost of those junked wells on them?
In the hypothetical?
Well, I think let's go back and ask and review the questions that Ms. Sandoval asked you. She asked you if Mewburn had decided after it had the 2 failed attempts that it wasn't going to drill a mirror well. Would you have passed the costs on to the parties? Do you recall that question?
After, we would have proposed the wells pursuant to the orders because we were required to.
You would have proposed the wells that you had already junked after you got an order?
We were required to, yes.
And would you have informed the parties that those wells had already been attempted, that you had already attempted to drill and those attempts had failed?
Probably not. But
so you're saying,
like I said, this isn't the case. These were substitute wells. We kept drilling the same well.
Well, I'm just going back to Ms. Sandoval's hypothetical, which was if you had not decided to drill the mirror well, would Mr. Ragsdale have been required to pay those costs That's how I interpret her question. So let me ask that to you. If those-
His requirement would be to make an election under a proposed order or proposed well.
So are you saying that you would have proposed those wells to Mr. Ragsdale after you had failed in your attempts to drill them? And you would not have informed him of those failed attempts, but you would have asked him to elect to participate, even though you had no plans to drill a replacement well?
We are required to propose the well. If in a different hypothetical, if we would have made a good well, I still would have had to propose the well to him. I have to propose the wells under the orders. I have to.
I don't think you're answering my question. My question is, would you have sent an election letter to Mr. Ragsdale after you got an order and after you had failed to drill those 2 wells and was failed in your attempts to drill the 2 wells, and after Mewburn had already decided not to do a replacement well, would you have asked Mr. Ragsdale to elect to participate so you could recover those junked costs?
Yes, I have to.
And would you inform Mr. Ragsdale that you had already tried twice and had failed and had no intent to drill another well?
No. After he makes an election, yes, we would.
So you would hide the fact that Mewburn had incurred $3 million worth of costs trying to drill 2 wells. You would hide that fact, ask Mr. Ragsdale if he wanted to participate, and then after he elected to participate, then you would say, you owe us your share of $3.1 million and we're not going to drill a substitute well?
It's
That's
industry,
what Mewburn would have done?
it's industry standard. I do it on both sides. We don't provide well info until a party has elected to participate. I can't make certain, I can't go one way this way, one way this way. I keep it consistent. We provide information to participating parties.
Has that circumstance ever occurred to Mewburn? Has Mewburn ever been sent a letter, an election letter, by an operator who has failed in its attempts to drill the well that is the subject of the election letter?
We don't have non-op interests. So we're not subject to any pooling orders. We're strictly an operator.
So when you say on both sides, you don't mean when you're operating and when you're not operating?
I mean, successful or not successful. I don't share information. It's not fair to the participating parties who have paid for that information for me to just share it to parties who have not paid for their share of the costs and the information.
Is it fair for you to hide critical information from a party who has been force pooled when you send them an election letter and ask them whether they want to participate in a well in which you've already incurred $3 million for failed drilling attempts? Is that fair?
I'm not hiding it. I'm just not giving information to people who haven't paid for the information. Like, that information could be valuable to someone else who wants to drill in that area.
Right, but you're asking them to commit to something in which you've already failed, and you've incurred $3 million in your failures, and you're asking them to elect to participate to drill a well that you've already drilled and failed to actually drill a produced well. I mean, are you saying that's okay?
It's industry standard to propose a well after an order's been issued, before, during, or after the drilling. I try to do it by the book every time and propose it as I'm supposed to.
Is there an industry standard that you can refer me to? I mean, is it like an AAPL principle that I can find in the Landman's Handbook?
A standard to propose a well before it's like, the standard is that we propose wells and then we drill them.
But here, I'm sorry to interrupt you. Here, what you did is you drilled them and then you proposed them.
I proposed, so this well is considered one well with the substitute wells. I proposed it March 19th of 2019. We have a substitute well, it's still classified as the same. Then we have a second substitute well, so it's still classified as that same well. I proposed it, I gave him the opportunity. It's not like I never proposed the well. He had the opportunity to participate. If he would have signed the JOA, he would have had all of this information.
So you're saying if you
he
don't
had-
sign the, if you're saying if you don't sign the JOA, then you're just out of luck? You don't get the information that you should have to elect when you're entitled to participate under a forced pooling order?
So information, you get entitlement to information once you are a participant. That is 100% industry standard. We don't give our information out to, we don't have like a website, here's all of Meburn's information. I'm not sure where that question is going.
Well, let me ask you this. Just hypothetical. You've been qualified as an expert here. Say you didn't work for Meberne. Say
Okay.
you worked for another company, and that company was a non-operating working interest. And there was another operator, and they failed in their attempts to drill 2 wells. After you sent out the well proposal and asked them if they wanted to join the JOA, and they decided, oh no, we're going to wait till we get force pooled. And then we'll elect to participate. But before it gets force pooled, that operator, who you don't work for, makes 2 failed attempts to drill the well and incurs $3 million in cost. And then subsequently, after they failed in their attempts, they get a force pooling order. And they come to you, and they don't tell you anything about the failed attempts. But they ask you whether you want to elect to participate. You're you're effectively representing, or I'm going to say, not you, the operator is effectively representing that we're going to drill these wells. And this is your opportunity to participate. Okay? But if you've already drilled the wells and failed, you're misrepresenting by sending them that force pooling order and asking them if they want to participate in a well
I'm
that's going to be drilled.
to that characterization.
How
Go
would
ahead
you
and answer.
feel? How would you feel as the non-operator
Hold on,
in that
hold on.
situation?
I think, Ms. Shaheen, you're bordering on testifying at this point. Can you please ask a question of Mr. Robb?
I will. I'm sorry. I'm just so astounded by his answers. I'm flabbergasted. Maybe I think I've made my point there. I would like to go back to the questions that I was asking Mr. Robb. When Meberne receives a pooling order that pools a unit for the purpose of multiple wells, let me back up. Meberne often receives orders that pool multiple wells. Is that correct?
Yes.
And when you get such an order and you propose it to the parties who have been force pooled, do you send out an AFE for each well?
For separate, if they're classified as separate wells, then yes, because
is
they're different wells.
Okay, so let's take a look at the order. In this case, that's R-20895, and I'm going to put it up for you. I believe that's attachment D. And I'll share my screen. Can you see that, Mr. Robb?
Yeah, I have it in front of me.
Okay. So this is the order R-20924-A. Do you see that?
Yes.
And if you scroll down, we'll get to the exhibit A that I'm assuming Mr. Bruce provided to the division here. You see that?
Yes.
And do you see kind of middle of the page, it says proposed wells?
Yes.
And it's got the 1015 1H, the 1015 2H, and scrolling to the next page, continues on the 1510 1H, the 1510 2H. Do you see that?
Yes.
So this order pooled that unit for the purpose of drilling 4 wells. Is that correct?
Yes, there are 4 wells listed.
And did you see it send out an AFE for each of those wells?
No.
And yet that, I believe, if I understand your previous testimony, you just told me that Mewburn's practice is to send out an AFE for each well that's pooled by an order. Is that right?
That we plan to drill, yes.
And did you plan to drill all 4 of these wells?
At one point, yes. So we drilled the 1015 B1 AP, the 1015 B1 AP number 2H. That's a substitute for the other one. And then we drilled the 1510 B3 PA number 1. Since we did not propose the 1015 B3 AP number 1 within the allotted time, we cannot drill that well. And we
Why
didn't drill it.
why didn't you propose it within the allotted time?
Because we moved to the 1510s.
So Mewburn never intended to drill all 4 of these wells. Is that correct?
That's incorrect.
Tell me at what point Mewburn decided it was going to drill all 4 of these wells.
Well, we intended to drill the first 2, and then we planned to drill the next 2. We were still kind of deciding what our plans were here. And like we said, this is the first time we've ever done this. So we weren't sure on the exact practice. So we thought better safe than sorry to include every well in this spacing unit that had the potential to be drilled.
And have you ever in the past, when you have an order that identifies 2 or more wells, or have you ever used one of those wells as a so-called substitute well for a different well in that order?
This was the first time.
Who at Mewburn made the decision that you could do that?
It's not us, it's the regulations that decided we could do that.
And can you tell me what regulation allows you to take one well in a series of multiple wells in an order and decide that you're going to use that as a substitute well?
I believe I testified to this yesterday, if we can just pull that. If I've said it at least 3 times in this testimony.
Are you saying that an order that pools multiple wells, that you can just simply decide that one of those multiple wells is going to be a substitute well? Is that what you're
I
saying?
object. This question has been asked over and over and over again, and both he and Mr. Cute have referred to the regulations about drilling substitute or replacement wells. It's found in the division's regulations.
I understand that, but it's inconsistent with his previous testimony, and that's why I'm just trying to explore it a little bit more. Let me go back and look at my notes here. Are you aware, Mr. Rob, that the statute 70- I believe it's 70-2-17 actually refers to the well that is pooled?
Isn't that you can pool a well before, during, or after drilling?
I'm not the person who's testifying here, so you don't get to ask me questions. If you want me to clarify my question, I'm happy to do that.
Could you clarify your question, please?
Okay, are you aware of section 70-2-17?
Yes, I'm looking at it right now.
Ms. Shaheen, do you know you're sharing your notes?
Oh, no, I'm sorry. Thank you so much. Let me stop sharing. Thank you for letting me know. And that's a statute that allows a party to seek to force pool other mineral interest owners. Is that correct?
Yes.
And it refers to the well, correct?
It refers to a common source of supply.
And elsewhere in the language,
I don't think it responds to a specific well, though.
But isn't it practice? Isn't it industry practice? Let's call it industry practice. And I think you testified earlier that it's Mewburn's practice to propose to send an AFE out for each well that is pooled in a pooling order, correct?
That we intend to drill, yes.
And didn't you represent to the division that you intended to drill all 4 wells?
At the time, but then we decided to flip the service locations.
So there was a time when you intended to drill all 4 of these wells.
At least 3 of them.
And-
We drilled, I guess the B1, at the end of the day, we did not drill the B3, the 1015 number 1. And that was our decision. The orders do not state that we have to drill every well that we pool.
But the orders state, the orders require, and it's a practice, that you send out an AFE for each well that you're
That
going
we-
to try to drill, right?
Yes,
Did you ever send out an AFE for the 1015 2H?
1015 2H.
And let me clarify that.
Yes.
Did you ever send out an AFE, other than in the well proposal? Did you ever send out an AFE with an election letter to Mr. Ragsdale for the 1015 2H?
Yes, it was included in the substitute well AFE that we sent. So they're all classified as one well because they were substitute wells.
And
As
did the notice letter say that?
My proposal letter said that to Mr. Ragsdale for that well.
Okay, so he never got an AFE for the 1015 2H until after you had already decided not to drill it.
We drilled it.
Sorry, until after you had drilled it.
He received it in March of 19 as well, before we drilled.
He received it as part of a well proposal, right?
Yes,
He didn't receive it as part of an election letter under a forced pooling order.
he did receive it. It was part of the, like I said in my proposal to him, the 1510 2H was a substitute well for that. So they're all classified as one well.
That's Mewburn's position. That's your position. But when I look at the election letter,
Of course, it's Newburn's position. Move on and ask a question rather than rehash what's already been testified to for hours yesterday
Well,
afternoon.
Mr. Bruce, I'm not getting an answer to my question. And I'm asking him whether Mr. Ragsdale ever got an AFE for the 1015 2H with an election letter under a forced pooling order. And he's trying to tell me yes by referring to the 1510 2H. So I'm not
He
getting
said-
an answer.
Let's, guys, stop.
Okay, I apologize. I
If
apologize.
you want, Ms. Shaheen, if you want a yes or no question, I suggest you ask for a yes or no answer. Otherwise, we have gone over some of these things multiple times at this point, and the witness is not obligated to give you the answer you would like. He's providing the answer that he can. So if I suggest reframing your questions if necessary, but can we move on, or at least reframe
Yes.
questions, please?
Yes, and this will be my last question, I think. I'll just try to ask the same question one more time, but in a better way. Did Mewburn ever send Mr. Ragsdale an election letter and an AFE, the 1015 2H?
Yes.
And can you show me in the record that election letter with the AFE for the 1015 2H that was sent to Mr. Ragsdale after the forced pooling order was entered?
I believe it's Exhibit 5.
Okay. And that's Exhibit 5 in your exhibits, in Mewburn's exhibits, or in Mr. Ragsdale's exhibits?
Of yours.
Okay. Let me see if I can pull that up. And I'll share my screen. Can you see that?
Yes.
Okay, so it's your testimony that this election letter included an AFE for the 1015-2H. Is that correct?
Yeah, you can read the second paragraph.
Well, I'm not looking at the paragraphs here. I want to see the AFE for the 1015-2H. So here's the first AFE. Which well is this for?
This includes the 1015 B1PA number 2H, number 2HY, the 1510 number 2H.
Can you tell me where on this it refers to the 1015-2H?
Second page, or sorry, the first page.
Show me, can you tell me where on the document it refers to the 1015-2H?
You got to scroll up.
Scroll up. So here, if you see my cursor, IBEX 1510 B1PA FedCom number 2H.
You can't just pick single documents out of a multi-document thing that was sent.
Do you want me to look at the next page? Let's look
The
at the
previous
next
page, please.
The previous page is the letter. I'm looking for the AFE, not the letter.
I can't answer this if you can't scroll up. I'm sorry.
If you can point me to the AFE for the 1015-2H, I'll go to it, but I have not seen it. And I'll just scroll down to the other AFE that is here.
Okay.
And can you tell me what AFE this is?
Yeah, that's the 1510 B3 PA number 1.
Okay, so it's not the 1015-2H, correct?
Nope.
And let's scroll a little farther. That's the end of the AFEs. Okay, I have no further questions. Thank you.
Thank you. Mr. Bruce, do you have any redirects?
Very briefly, Mr. Robb, if Mewburn had, well, they did commence the 1015-2H and then junked it and did a substitute well, if once that was junked, if Mewburn had decided just not to drill the well and laid off for a couple of years before doing anything, and you did get the pooling order on those on that well in October, I believe, would you have sent Mr. Ragsdale an election letter?
Yes, I would have been required to.
But it wouldn't have been for the full $9 million, would it? It would have been for the $3 million that was spent.
Correct.
Okay. Just one other thing, and this goes back to Mr. Ragsdale's testimony this morning. He was talking about the right to drill, et cetera, et cetera. Mewburn, when it commenced the wells, it had an interest, a working interest in every quarter section in the well unit, did it not?
Correct, we did.
And Mr. Ragsdale said something else that he stated that you testified that Mewburn assumed the risk of all those costs. He said that you testified that. Did you ever say that?
I did not. We assumed the risk that Mewburn would not be deemed operator at the division. The costs are recoverable under the previous rules and regulations that we pointed out earlier.
That's all I have, Madam Chair.
Thank you. And thank you, Mr. Robb, for your time yesterday and today. I'm going to propose a 5-minute break. Let's come back right after 10:30, please. Okay. So at this point, I believe the commissioners should probably discuss how we want to proceed. I think there are a couple options at this point. And so, Mr. Moiner, I just want to confirm, until closing arguments are made, we don't close the whatever, close the record, right?
We will not close the record itself. We're going to close the evidentiary portion of the hearing now. So the record is going to remain open until a final decision is made, essentially. So yeah, well, my advice here is to close the evidentiary record at this point, and then we can proceed to next steps for the case.
Okay. So at this point, the evidentiary record is closed. All right, commissioners. So I think the two options at this point are to proceed with oral closing statements, or to direct the parties to provide written closing statements by a certain date, and then deliberate during potentially our next scheduled hearing. Those are kind of the two options that we have. I would like to hear feedback from both of you as to how you would prefer to proceed.
Madam Chair, I'd prefer to have written closing statements. I think it would be very helpful to see some of the themes we've looked at here of the past 2 days, sorted out and elaborated upon, with particular attention to legal precedent and, of course, our governing rules and regulations.
Madam Chair, I do share the same view with Mr. Bloom. Thank you.
Okay. That is not my normal preferred option, but I think for this situation, it makes sense. Ms. McFarland, when do you think we can get transcripts for yesterday and today?
Well, I think it's around 240 pages. I kind of looked at it last night, and I'm working right now on the OCD from the 6th. If I talk to them and they have no hearings that they have to have something on really quickly, if somebody's waiting for, then I'll start this right away, because they've always told me to put the commission first. So I can start it right away. I'd say maybe 10. I'd like to do it earlier, but I'm going to say 10 days.
So let's see. 10 business days, I'm assuming, or 10 days?
I think I could do it in 10 days. That would be like probably 8 business days.
So by the 24th or the 25th?
Yeah, if that's what that is. And I will try to get it earlier. It just kind of depends how it goes with checking documents, and there weren't too many on this, so that speeds it up.
And I can check with division as well, but this should take precedent unless there is something just absolutely critical on that latest division docket. Or not precedent, priority. I don't know what I said.
That's what Examiner Ranker has always told me, is to put yours ahead. But I thought I would check with them, because there were quite a few motions on that day.
Yeah. Okay. All right. So I'm just looking at the calendar. So our next regularly scheduled OCC is the 22nd of February. We moved it due to the session. So if we get the transcript by the 25th at the latest, could we get statements? Would it make sense, Mr. Melander, by the 4th?
No, Madam Chair, if we get the transcript, so if all things being equal, I would recommend like a week. But no more than that, because we want to be able to have this. We want to have everything that the parties submit, and then commission time, which is going to be a little crunched before the next meeting due to the legislative session. I want ample time for both the commission and myself to review the closing arguments and authorities and so on. So I'd say February 1st. I mean, what we could say 7 days from the receipt of the transcript. The transcript is going to, if I remember correctly, will arrive in Ms. Davidson's inbox most likely, and she'll need to be diligent in farming that out like immediately or as soon as possible. So 7 days from when Ms. Davidson forwards the transcript. Because otherwise, I'm afraid to put a date certain on these sorts of things, given that transcripts are fluid. So I think 7 days from dissemination by the commission of the transcript. That I think
Okay. I would like to put a page cap on this as well. I think probably no more than 10 pages.
I think that would be good. 10 pages, and then perhaps put a limit on any attachments or exhibits.
What page count for attachments or exhibits would be reasonable?
One of the easy shortcuts is to go to like something like the rules of civil procedure. So maybe 15 pages of attachments, 10 pages of writing.
Okay.
Because the parties can also cite to the record, but if there's something in particular that perhaps they want to highlight or bracket or otherwise draw your attention to, that gives the parties some leeway there to attach those with that type of information in it.
Okay. Great. Are there any other details we need to discuss? I think as Commissioner Bloom mentioned, specific attention to precedent from the past and the legal pieces of OCD statutes and regulations as an emphasis, but it is your closing statement, so you may state whatever it is you wish to state, I guess. All right, do we need to make a motion, I'm assuming?
Motion to what, Madam Chair?
For the written closing statement?
Yes, that would be a good idea, just to make it nice and formal.
Is there a motion let me pull the case number up again. Sorry. Is there a motion in continuance case number 21324 or de novo case number 21902 to require written closing statements by the parties due to the commission no less than 7 days after receiving the transcript and being no longer than 10 pages of written closing arguments with an addition of 15 pages of exhibit attachments?
Madam Chair, I so move.
Is there a second?
Madam Chair, I do second.
Mr. Molander, would you do a roll call, please?
Yes, Madam Chair. Commissioner Mpoma.
Yeah.
Commissioner Blue.
Approve.
Madam Chair.
Approve.
The motion so carries.
This will be heard, I guess, do we need to add in that motion that this will be discussed on the next docket in February?
No, Madam Chair, you can just make that announcement because that's the next regular scheduled meeting.
Okay, we will continue this case to be heard at our next regularly scheduled meeting on February 22nd, and to deliberate as necessary. All right, next item on the agenda, pending litigation. Is there an update for the commission, Mr. Moander?
Yes, Madam Chair, and this is in case A-1-CA-39578. Appellant had a deadline of December 20th to file his reply brief. That date has come and gone with no such document filed. Under Rule 12-210 sub E sub 3, the matter at this point is before the court for a decision. If the court elects to hold oral argument, I will receive notice. We may not receive an opinion on this for a while. We may not receive notice for a while, but at this point, the case is now officially ripe for decision. So hopefully the next thing we receive will in fact be a written decision from the court.
Thank you. Is there any other business in front of the commission today? All right, our next regularly scheduled meeting is February 22nd, which is a Tuesday, so it's a little bit different than our normal due to session. And with that, it is 10:45 on the 14th of January, 2022, and we will adjourn for today. Thank you, everybody.
Have a good weekend, everyone.
Happy Friday.
Thank you.
Yeah.
Right.